Our next session is entitled Practical Issues of Resolving Disputes Before the U.S. Patent and Trade Office. And I'm going to introduce Ann Craig, and she'll introduce the rest of the panelists. Ann Craig is the Director of Intellectual Property at Harvard University, where she works in the Office of Technology and Development. Prior to joining Harvard, Ann was also Chief Patent Counsel for several biotech and pharmaceutical companies and spent several years in private practice at a Boston-based intellectual property firm. Ann holds her BS in biology from UMass Amherst. Her JD is from New England College of Law, and she has a master's in management from Cambridge College, she went to law school. She attended night school while working as a public school science teacher during the day, correct?
Yes.
Anyway, we want to welcome Ann and let you introduce the rest.
Thank you, Jim. Thank you, Dean Myers, and for inviting me here, and thank you, Director Levin. And I also wanted to just let you know, from the Northeast perspective, that your Dennis Crouch is a rock star. Very well respected. His blog makes its way to many of the people in the Office of Technology Development, which is
Maybe use one of the microphones.
Does that work?
I think that's better.
Thanks. So I just wanted to thank you very much for inviting me. I'm really glad to be here. I was invited because I'm a runner and I have a stopwatch. What we're going to talk about here is really, we have wonderful guests. Jaron Brunner, who is an MU Law School graduate, here in the Certificate of Study in Dispute Resolution, so you'll hear a lot about the theory and strategies with which you're familiar, I'm sure. He worked as research assistant for Professor Crouch, and his undergraduate degrees in computer science from UC Riverside. Following law school, he attended George Washington School of Law, where he got his LLM with a focus on intellectual property law. Jaron is associate at the Seattle-based firm of Davis, Wright, Tremaine, and was previously a patent examiner at the USPTO in the area of network and network security. So, thank you for coming. And our other guest is Matthew Smith, who recently joined the West Coast firm of Turner Boyd, one of our sponsors. And he's previously with Foley Lardner firm that ran their patent office trials group. Matt is known for work on complex patent issues that may involve multiple patents being enforced across multiple parallel actions, which you can imagine is a nightmare. In addition to his extensive practice experience, Matt's the author of several legal treatises, including one on patent office revocation proceedings, inter partes reexamination proceedings, in which Harvard has been involved, and design patents. In the past, he's also taught at George Washington as an adjunct faculty member with a focus on international comparative patent law, which I'm sure was very exciting. Mr. Smith holds a BS and JD from Wisconsin and Madison, and has a second BS in electrical engineering from the University of Hanover in Germany. And the way this is going to be organized is Jaron's going to talk about the use of dispute resolution in the process of prosecuting a patent application, and then when he's done with that, then Matt's going to talk about the use of post-grant proceedings. So, gentlemen?
Thank you for the introduction, Anne. So I'm going to talk initially about how prosecution is like a negotiation, then discuss a little bit of negotiation theory and strategies that I think are useful in patent prosecution, and hopefully tie in my experience as an examiner in dealing with attorneys, and also my experience as an attorney dealing with examiners, and really focus this on some practical tips that prosecution attorneys can use, and hopefully improve not only the pendency of their applications, but also the strength of applications. Because while maybe filing for one patent is not as expensive as litigation. You get a lot more patents, as our first panel discussed. Your cell phone may have hundreds of thousands of patents, so somebody has to pay for all of those. And your client, at the end of the day, if their patent gets invalidated, they don't have anything to show for all that money that they've spent. So when you boil negotiation down to its bare minimum, it's really just a communication between two parties when one side wants something from the other. So in the case of prosecution, the examiner has the ability to grant the applicant a patent, and the applicant has the desire for a patent to protect his or her invention. So what do you need to know about negotiation to end up negotiating a patent application? And I think that one of the things about negotiation is that it favors the repeat player. So some of these strategies and topics I'm going to talk about are already best practices in use, and maybe they'll just sort of elucidate why these things are best practices. But I do think that a focus on negotiation when preparing an application and when responding to office actions and amending your claims can ultimately lead to a better patent application. So my idea here is that principal negotiation, and specifically using principal negotiation when dealing with the examiner, is the best strategy. Principal negotiation is proven successful in a collaborative environment. So in the patent prosecution example, your examiner may end up working with you. They may consider themselves as an aid to the applicant, sort of guiding them in the direction of, okay, what's the prior art and where is this thing different? But also there's plenty of examiners that see themselves as gatekeepers, and they're very adversarial. And I think attorneys, we're trained to be zealous advocates. We are adversarial by nature. So without this focus on negotiation, we can end up just butting heads with the examiner, costing lots of money to the client, and not really getting anywhere closer to allowance. So principal negotiation, what does that involve? Well, there's 7 elements, but some of them are fixed, especially in the patent prosecution scenario, because you can't do as much as you can in the real world. But the 3 things to focus on are interest, and that's for both parties, your client and the examiner. You also want to focus on alternatives. And interest is just your needs, desires, what does each party want. And for the examiner, that's tied directly to the count system. And for those of you who are familiar with the count system or not familiar, essentially the USPTO gives an examiner a certain number of times to get an action out, to get an application to allowance, and they get job credits for this, and you get a score based on your production, how much time it takes you. So the examiner's interests is the count system. The client's interests are varied, but it's important as attorneys to understand what those are. The other thing is alternatives. So for the examiner, his alternative is always not issuing you a patent, is to send you a rejection. And finally, you have options. So options is any and all form an agreement can take. And in the case of patent prosecution, that basically just means, what is my claims going to look like? Because that's what you're arguing. You're arguing with the attorney, here's my claim to invention, here's how I've described it, here's how it's different from the prior art. And when you focus on these things, it's important to use negotiation strategies. And the 3 important strategies that are effective in patent prosecution are contending, yielding, and problem solving. So how do those 3 work real quick? The idea is that there is a point at which both sides have a win-win, and that's called the integration potential. That's what you want to find as an attorney. That's how you're going to get the examiner to agree to your claims and to get to allowance. Now, I think the majority of attorneys and probably examiners think of it as, okay, we're going to compromise on claim language. You want a module for X, or you want a compound Y in family Z, and they're going to compromise on, okay, well, I'll let this limitation go if you bring in this dependent claim. And compromise, while it seems like you're getting to an agreement, the problem with compromise is both sides are making a concession. So integration as opposed to compromise means that we're finding a win-win. So how do you find a win-win for the examiner? Well, that's in his counts or her counts. In the job credits they get, whether it's counts or examiners also get other time for interviews. Currently, the USPTO has an after-final pilot program which gives examiners 3 hours of other time for considering amendments after final. So the idea is that you want to, and let me briefly explain the 3 strategies. So problem solving involves brainstorming. For example, I call an examiner, I say I want an interview, we have an interview, and we sit down and we discuss different claim options. What if I say, the claim's this? What if I import limitations from dependent claim 5 into claim 1? And the idea is during the interview, you don't want to evaluate the claims. You don't want to say, oh, is this allowable, is this allowable? You just want to generate options, have them available, and then when you go back to respond to the office action, at that point, you can consider what you want to do. You can yield, you can do more problem solving, generate more options, or you can contend. So yielding involves reducing your aspirational value, which means I'm amending my claims. So initially I claimed very broad, I'm covering everything under the sun. The examiner makes a rejection, he interprets my claims. I come back, I need to yield. I need to reduce my aspirational value, what I'm getting, and accept less so I can get an issued patent. Your other option is contending. And contending really just means expressing to the other side, to the examiner, that you're going to stand firm on this. And there's a variety of ways of doing this. You can do it in an interview. You can just submit arguments. You can file an appeal. An appeal is probably the most contentious thing you can do during patent prosecution. But the good thing about appeal is it doesn't further preclude negotiation. You can appeal. It forces the examiner to meet with their supervisor and another examiner to critically think about the arguments presented, the claims, and the prior art, and they may reopen prosecution, or they may go ahead, file the brief, the examiner's answer, and at that point you can decide, okay, should I file a brief? Should I file a brief and then wait and file an RCE and recontinue negotiation? So these 3 strategies, problem solving, yielding, and contending, aren't necessarily cyclical. The nice thing about negotiation and these types of negotiation strategies is they work really good in an iterative process. So both sides come in wanting their aspirational value. They want to get as much out of it as possible. So the applicant wants the broadest claim coverage they could possibly get. They want to cover all possible future improvements. And the examiner wants to limit the application to the core of the invention, just what is invented. Let people build upon the application and add to the prior art. So in each successive round, you reduce your aspiration value, you get closer to the middle. So the patent system is great for that because we have successive rounds. We prepare our negotiation, or we prepare our application, we prepare that for negotiation with the examiner. We file that, that can be considered a round. They respond, first office action. And the nice thing about the count system, and which is good for us, is that an examiner is going to get the majority of his counts, about 60%, 62.5, I believe, for a first office action. So that means the examiner's biggest incentive is to get issues out on the table as soon as possible. So a lot of practitioners, they like to claim really broad start off. We're going to hide the ball, so to speak. And the problem with that is that the examiner then makes an initial read, finds the closest reasonable interpretation, and again, the examiner has the power of the broadest reasonable interpretation. So if there's any way of reading your claims onto the prior art, the examiner is going to do that, and they're going to issue a rejection. And you may have inadvertently added extra iterations to this step because you started off so broad. So the examiner is going to cite art that's not necessarily relevant. You're going to have to amend the claims, argue that art is not relevant, and then now I've gotten myself to final rejection, and I force my client to pay for an RCE. So how do I use these strategies in preparation? Well, one of the things you can think about is when you draft your claims, I sit down and I look at my claims, and I ask myself, do these claims satisfy the examiner's interest better than his alternatives? So if it satisfies his interest better than his alternatives, he's going to allow the claims. Now, we probably, as practitioners, if we get a first office action allowance, we're going to say that we've done something wrong, we've left something out on the table. But I think the idea should be to use claim terminology and possibly even submitting applications with IDSs, which I know is not very popular, but to direct the examiner towards where you want them to go. Essentially what you're doing is anchoring, and for those of you not familiar with anchoring is essentially this idea that during negotiation, whatever the first figure that's thrown out inadvertently biases every other number that goes out. So when I'm going to buy my used car, I say I'll pay $500 for this, and even if I've overvalued that car, all the subsequent negotiations are going to be biased by that. So he says, oh no, $550. Well, okay, that's still closer to my negotiation. I say $510, it's still closer to the initial value, so maybe I'm getting a good deal, when in fact I'm not. So anchoring helps. If we anchor somewhere that's more realistic, and to do that, there's two more principal negotiation elements that I'd like to talk about, and that's legitimacy. And legitimacy is just pointing to objective standards and communication. And communication is any and all forms of communication that the negotiation can take. So it works both ways, legitimacy. As attorneys, I don't think we really ever consider whether the examiner has a legitimate argument. Right? We make arguments and we point to the prior art and we say, we've claimed limitation X, the prior art doesn't show limitation X, therefore it doesn't anticipate, or it's not obvious because it doesn't teach all the limitations. But we very rarely stop and consider, okay, how is the examiner interpreting my communication, and how are they reading my arguments, my claim limitations? So thinking about objective standards, and it's pretty easy in the patent sense, it's just what's the prior art, what's presented, does this fairly and reasonably read on my claims? And doing that will help us respond to office actions. Hopefully, when we do interviews, we can clarify issues like that. But ultimately, using those three strategies, problem solving, yielding, and contending, and also thinking about options, interests, alternatives, and as needed, legitimacy in terms of the communication. I think as practitioners, we can get a better application, get something that we can look in litigation and say, okay, here's the file history, here's how the examiner communicated, here's the first set of claims, here's the prior art. Make it very clear that this limitation differentiates the claimed invention from the prior art, what was presented. I think then we've made ourselves a stronger case, a clearer case for allowance, for validity of the patent, and hopefully got it in less time.
I'm wondering if the new accelerated examination alternatives are modeled in this particular way. Have you had experience with that as an examiner? Or?
Yes. So the count system, which is, as I mentioned, the primary incentive for examiners, was unchanged for 30 years. But in 2009, David Kapos was then acting director of the USPTO, decided it was time for a change. And one of the things they wanted to do, along with reducing pendency and instituting track 1, track 2, track 3, was to facilitate negotiation between the examiner and the applicant. Now, that wasn't expressly stated, but really what they wanted to do was move the the bulk of the counts an examiner gets to the very early stages, but like I mentioned, 60% of an examiner counts is for the first office action. So these issues get out on the table earlier. So it facilitates this type of negotiation. It actually encourages this type of negotiation. Whereas before, and even now, I think that the practitioners are slower to adopt this theory than the examiners. I mean, you have an RCE backlog now that is quite large, but it used to be you'd file RCE and RCE, and you wouldn't get an allowance until you got to that RCE. And now, you know, the track ones, it speeds up your time in the queue, but it also fits into the bigger picture of we want to get these issues out on the table as soon as possible and get them all resolved at once. You know, it used to be for an examiner, what you could do is as soon as you found one rejection, whether it's a 112 first, you know, 101 rejection, an anticipation, obviously a rejection, you find the one rejection, you sent it off, and you were done. Now, as an examiner, you're expected to do a complete examination. So even if it's a 101 issue or a 112 first issue, I still need to look at all the claims as an examiner and still give you art, still give you the 102, still give you the 103, so all of those issues are on the table, and when the applicant returns their response, they have to address all of those issues. So yeah, I do think that the idea is to facilitate this type of negotiation.
Great, thank you. Matt?
So I'm going to change worldviews, and Jaron's topic was interesting to me. We had a sort of confusing discussion early on about what we should be talking about here because we have such different things to talk about. In Jaron's situation, the fundamental dispute is between the applicant and the public employee who is the examiner. Their motivations, as Jaron talked about, are almost orthogonal, right? If the applicant wins, it doesn't mean the examiner loses, and vice versa. Actually, one of the things I did want to ask you was what is the countervailing motivation on the count system is? Because if it was just the count system, you send out bad office actions all the time. You got to do something, right? Why?
Yes. So you do have quality review as an examiner, and unless you're a primary examiner, somebody else needs to sign off on all your actions. So there is quality review there. And also, I think, for the most part, examiners everybody wants to do a good job in their job. So I think examiners, there are some cases of examiners not really doing much and just sending out stuff. But I think the quality review is there, your promotions are based on that. And so there are, you know, checks on that, so the examiner just doesn't send out whatever.
And I'm sure they don't want to be overturned. I mean, if you get overturned a lot, if you file an appeal, notice of appeal,
exactly.
And
so
you get knocked down a few times, that's not very good.
Yeah, and the other thing is, so as an examiner, you never want to do free work. You want to get a count for whatever you're doing. And if you get overturned and the board says you have to reopen prosecution, well, I'm not getting any accounts for that. You know, that's work I have to do for free. And essentially, what's going to happen is the board is going to say, you got it wrong, you have to do work for free, and I'm just going to say, whatever you say, board, sign it off. Spend as little time as that as possible. So
this is all very good to know.
So, of course, in the post-grant world, we have two private parties contending against one another, and the office's role then shifts to being the facilitator in the process. And so I look at this part of the discussion as not, what sorts of private advocacy negotiation techniques can you apply to resolve this dispute, but rather, is this process a suitable dispute resolution mechanism, and how does it compare to other sorts of dispute resolution mechanisms? And that is in part due to the fact that during the legislative process, it was put forward by people driving the implementation of inter-parties review, post-grant review, covered business method, patent review, that these could potentially be lower cost alternatives to litigation. And the same thing happened back in 1999 with the AIPA, which introduced inter-parties re-examination. The idea was that patent litigation was just getting too expensive and we needed some other way to resolve these kinds of disputes. And I remember back in that time when I was graduating from law school, to be the end of the last century, was studying for the patent bar and thinking, there's this new stuff that just got passed, this new procedure. Do I actually have to know about it? And I decided that I didn't have to know about it. And I imagine that there's quite a large proportion of the audience that really hasn't touched on this subject. Has anybody actually worked on one of these or studied extensively inter-parties review, post-grant review? Yeah, okay. I suspected you would raise your hand, but you're probably the only one. So let me just give you the 1-minute introduction to this. These are proceedings that any party who's not affiliated with the owner of the patent, can initiate at the patent office after issuance of the patent to challenge the patent's validity. There are 3 different ones: inter-parties review, post-grant review, covered business method patent review. Almost all of the action right now is in inter-parties review, because inter-parties review is open to all patents, and has been since September 16th, 2012. Post-grant review is only available for patents that are issued from applications filed on or after March 16th of this year. So we're not going to have a lot of those patents for 5 or 10 years. We're not going to have a sufficient base of issued patents so that the very, very small percentage of them that actually goes into a post-grant proceeding will start to be a significant number. And then we have covered business method patent review, which only applies to business method patents. So there's a far fewer number of those out there right now. But we've got about 500 and some inter-parties reviews going on. So we know basically what that proceeding looks like in practice up until about the final oral hearing. How does it work? The party who wants to challenge a patent puts together some patents and printed publications and makes out a case under Section 102 or 103, anticipation or obviousness, writes up a petition, which is attorney argument, submits an expert declaration, which is the evidence that goes along with it. This is an evidentiary proceeding, so you have to have evidence for your positions. Then the patent owner has various chances to respond to that. There is a limited amount of discovery, which typically is just cross-examination of the experts who submit declarations. So much, much more limited in scope than a district court litigation. You can try to get other kinds of discovery, but you have to meet an interests of justice standard, and the patent office is very, very stingy with that discovery, and I think rightfully so. Then, after the patent owner responds, the petitioner replies, puts in the evidence record is essentially closed at that point, and you go to an oral argument, which is a kind of, basically appellate argument. It's like an argument before the board. These are decided by 3 judges of the Patent Trial and Appeal Board, so these aren't examiners anymore. They're legally trained as well as technically trained. They're trained in what they call contested proceedings, so they have some ability to facilitate the process between 2 contentious parties. And then they issue a final written decision, which can be subject to a request for reconsideration. That entire process is estimated to take maybe 18 to 20 months. And there is a statutory limitation on a portion of it, which is 12 months. And so you have this sort of confined period, which is faster than most district court litigations. If you include a subsequent federal circuit appeal, it might be sort of at the average time to trial from filing of a district court litigation. And the first question that comes up, I think, with respect to these is, are they fulfilling their purpose that was put forward in the legislative history? Are they really lower cost alternatives to litigation? And I think the answer to that has to be mostly no. And it's primarily because they don't have exclusive jurisdiction over the patent, at least jurisdiction that would exclude a district court litigation, as you would get, say, with a properly written binding arbitration agreement. Okay? So what that has led to, of course, is having these proceedings in parallel to patent litigation, which simply increases the cost. And the cost of these proceedings is, I think, higher than the last version of such proceedings, inter partes re-examination, which was in turn more costly than the prior version, ex parte re-examination, which was in turn more costly than the prior version, which was basically nothing. So we've seen this administrative route to challenging patents get more costly over the years. Now, in this version, I think there have been some significant improvements which give it the potential to be a tool which reduces the overall cost of litigation and reduces the burden on the courts. And let me say that there are I don't mean to speak categorically. There are certain instances where this is actually a very good dispute resolution tool. And I would say it's maybe 5 to 10% of the cases that I encounter. And that's where you have two parties, typically competitors, not NPEs, defendant type suits, but typically competitors.
Does everyone know what an NPE is?
Does everybody know what an NPE is? Non-practicing entity, I'd say, one step shy of patent troll in my mind. Somebody who owns intellectual property, asserts it, in a way that you could analogize to any number of different people, but sometimes to the inventor of the light bulb, for example. But asserts the intellectual property without actually making the product or competing in the industry. In my mind, a patent troll is somebody who does that while abusing the litigation system in some way. I'll just leave it fuzzy like that. But if you have a competitor type situation where the competitor is seeking to license a relatively small number of patents and they go to the accused infringer, and the accused infringer's response is, well, yeah, but we've been doing that since the 80s and we think it's invalid. And the patent owner says, well, what are you going to do about it? And the accused infringer says, well, we're going to put it in inter-parties review. And the patent owner says, okay, go ahead and do that, and then when you're done with that, come back and you can pay us some money. And in those sorts of situations where maybe the collectible damages are in the 6 figures or low 7 figures, neither party really has the incentive to go into litigation. In that kind of situation, inter-parties review can be an effective dispute resolution mechanism because you can probably prosecute one of those through the federal circuit for maybe $300,000 or $400,000 or maybe up to $1 million on the very high end. But it's definitely going to be less expensive than litigation. So in a certain limited subset of enforcement scenarios, it is going to be a good ADR mechanism, if you will. It's a public one, but it's still a good ADR mechanism. In most cases, however, you have co-pending litigation, so it's a litigation tool more than a dispute resolution mechanism. And I will say that in about half of the cases, people will move for stays. Let's say the accused infringer will move for a stay. It'll be contested and the judges will grant it. Okay? Now in those cases, you're going to put off a lot of the litigation expense until the end of the inter-parties review process. So typically these stays will look something like the case is stayed until the patent office issues a final decision from the inter-parties review process or a final written decision, which is slightly different from the inter-parties review process. Some judges have gotten a little bit more savvy about it. They've been burned by the length of time the re-examination took, and so they'll say, well, I'll stay for 6 months and then we'll check back in. But if you have a stay of litigation, then the inter-parties review has the potential to resolve a lot of the issues in litigation. Obviously, if all of the asserted claims are found to be invalid and no new claims come out that are threatening to resolving all of the issues. If the claims are found to be valid in the PTO process, then the estoppel, there's an estoppel that attaches to from these proceedings that will kick in either case, but if the claims are found to be valid, you know you're going back to litigation. That will limit some of the validity issues that are in the case. So in those sorts of situations, you can say, yes, maybe this is a mechanism for decreasing the cost of litigation. Now, it's a mechanism that is very much in favor of the accused infringer, right? Because the patent owner really doesn't get much out of the IPR process except this potential for estoppel, and the potential for estoppel is only for issues that were raised or reasonably could have been raised in the inter-parties review process. And you can only raise patents in printed publications in 102, 103 type combinations. That means that if you have, say, prior art that is not based on a patent or printed publication, it was a commercial sale or public use or something like that, you'll probably be able to use that in litigation. So there are ways around this estoppel effect. So I think for the most part, you can say that no, this is, it's very idealistic to say that this is a dispute resolution mechanism that's helping to reduce the cost of litigation. In fact, it is helping to fund my child's education. But in certain limited circumstances, you can see where that thought process was headed. Comparing this to other dispute resolution mechanisms, I think the most easily accessible analog would be arbitration, substantive arbitration of validity issues. And Kevin and George, I think, rightfully said that there just isn't a lot of that going on in the world. I studied this back in 2005, 2006, and tried to find actual instances of substantive patent law arbitration. And it's all confidential, so you can't just go out and read arbitration decisions unless you're looking at a jurisdiction which happens to publish the opinions in the matter of law. But it was very, very difficult to find. I did eventually find a couple of arbitrators who had claimed to have done substantive patent law arbitrations, although not very many. And it was this always sort of a shadowy proceeding with cloaks and a lot of candles and stuff like that. But one of the fundamental differences, of course, between an arbitration proceeding and an inter-parties review proceeding, you think they'd be relatively close. You're just swapping out publicly employed judges for privately employed judges. But this issue of confidentiality, of course, is huge. The proceedings in an inter-parties review are, with very little exception, some exception, but very little, public. So if you have a widespread licensing program where you are looking to license from dozens or even hundreds of potential licensees, they will all have access to the effort that is put in by the petitioner to challenge the claims of the patent. And even if you settle the inter-parties review, presumably that effort could be pretty easily reproduced in a subsequent inter-parties review by another party. Not the case, of course, with an arbitration proceeding where if you don't have access to discovery, in other words, you want to stay out of the litigation, it's going to be difficult for you to get into your licensing negotiation and have this ready-made invalidity argument already there. Certainly the effect on any enforcement action in a district court is going to be very, very different between inter-parties review and an arbitration. In my experience, this is actually a science unto itself. How do parallel USPTO proceedings affect litigation? There are a lot of different touch points. A lot of them are discretionary, so things like, does the district court stay litigation pending an inter-parties review, right? District courts and judges are all over the place on that, and they're right? 2 + 2 can be 3, or it can be 5, or it can be 4, and the court is always right because it's a discretionary decision. Do I, as a court, issue a preliminary injunction or not, in view of the fact that the PTO is reviewing invalidity? So a lot of those things are just discretionary. And courts tend to give more credence to decisions of the patent office, be they even interim decisions, than they do to arbitration proceedings. There are also points where the patent office decisions are binding on the court, and that just doesn't really happen with arbitration unless it's sort of a res judicata effect. Okay? But if it's not, then the patent office has the advantage of having a set of laws, if you will, that govern certain aspects of how inter-parties reviews will affect district court litigation. So, for example, there is the whole body of law about prosecution history, estoppel, and disclaimer. Right? There's certain things that a patent owner can say in a PTO proceeding that will limit the scope of the claims or limit the scope of the doctrine of equivalence. Right? That's governed by case law. There's certainly the estoppel effect, which is statutory. There is the more or less binding effect of the inter-parties review as a whole, which is set forth in section 252 of the statute. So when you get to the end of the inter-parties review, you know how that will affect, how the certificate that the patent office issues will affect the litigation between those two parties and will affect subsequent parties down the road. In arbitration, of course, you're not going to generate a collateral estoppel effect, whereas in the patent office, you will generate something like that. So those two types of things, I think, I would classify as the credibility of the patent office and the binding effect of the patent office on litigation. There's also the differences between how the proceeding is handled. For the patent office, as I said, there's a relatively limited and prescribed scope of issues. So you can talk about anticipation of a claim, you can talk about obviousness of the claim. If there are new claims, then you can talk about written description, enablement, that sort of thing. Only in very, very limited circumstances do those issues come up as to originally issued claims. There's also a very set procedure. All right, so for discovery, you're really only getting cross-examination by deposition of the other side's expert. I happen to think that that is a very appropriate level of discovery for these sorts of things. Having had the experience of managing inter-parties re-examinations from both sides, from the patent owner side and the challenger side, and then moving into inter-parties review, the one thing I really wished for in inter-parties re-examination, and I didn't wish for much else, was the ability to cross-examine the other side in some way, because you had this sort of, freedom in an inter-parties re-examination to submit positions that were pretty ridiculous and that would collapse under a certain amount of relatively logical questioning, which the examiners couldn't do. Sometimes they wouldn't think of it. And the parties weren't able to do either unless they, somehow got the deposition in litigation and were able to reintroduce it. So that, I think, was a very appropriate modification to the scheme. And in arbitration, of course, those types of limitations don't really exist. There's a lot more freedom, which begs the question, how do we decide what we're actually going to do in arbitration? And that points out one of the biggest differences, right? Arbitration is consensual. You actually have to agree to do it. And that's why there are probably a lot more inter-parties reviews right now than there are substantive patent law arbitrations. We really see substantive patent law arbitrations arising out of breaches of license agreements where they already have an arbitration clause. And as a result of this contractual issue, there's also an allegation of infringement going on. I do see that coming up a little bit more often than I did 7 or 8 years ago. We actually see that in practice now a little bit more. But still, the fact that you can go into an inter partes review without the consent of the other side is certainly one thing that's going to weigh heavily in terms of its significance as a dispute resolution proceeding. But in an arbitration, you can determine what sort of procedure you're going to be using. To a certain extent, you can determine the law you're going to apply. So I think it's still perfectly acceptable, and somebody can correct me if I'm wrong, in the U.S. to apply foreign patent law to U.S. patents and have a binding arbitration judgment come out of that. You could potentially rope in more patents worldwide and solve things globally if they're patents from jurisdictions that allow substantive patent law arbitration. And you can regulate the scope of discovery. You have more freedom to expand discovery, essentially, in ways you don't have in this patent office proceeding, this set of patent office proceedings. That means, of course, that binding arbitration can be a lot more expensive, I would think, than an inter-parties review, because the parties, I think, are going to have different motivations about discovery. And so in order to come in, they're going to have some sort of compromise. It's one of the things I think that is said about arbitration that quite often is not true. It's often not less expensive than the alternative proceeding. I mean, for one thing, you're paying the judges, and then it just depends on the scope of discovery and that sort of thing that you bring forward. We can talk about, for a couple of minutes, the ability of the parties to use dispute resolution proceedings within the inter-parties review process. And that's a shift in emphasis now too. Rather than looking at inter-parties review as a potential replacement for different types of ADR, we're looking at trying to solve the dispute. And the difficulty with that, I think, is that these are often disputes that transcend this PTO proceeding. There's litigation in the background, there's an allegation of infringement. Often it's in multiple countries. So as a practical matter, we are seeing mediation being used, but not necessarily in connection with the PTO proceeding. It's arising out of a district court proceeding, or it's arising out of an agreement by the parties to mediate what is essentially a global dispute. Using it within the proceedings, I think, would be unusual. I've never seen that before, partly because the Patent Office doesn't have a mechanism for forcing it upon you, which a lot of courts do right now. Certainly the Federal Circuit does. But it's also a proceeding that I think just isn't big enough in some ways. The issues aren't broad enough. They're not covering everything the parties are really interested in, and it's not expensive enough to really justify sitting down with a mediator and spending $5,000 a day or whatever you're going to spend on that to try and resolve that conflict. Arbitration, of course, would be something that would just never come up in this context, because you essentially be replacing the public process with a private one, and there's no sort of incentive to do that. So overall, I'm actually quite pleased with the process, and not because I do a lot of work in that area, but I think it is a step forward, both for patent owners and for people challenging patents. I think the decisions that we're going to see out of this PTO process are going to be higher quality, which means closer to what a blue ribbon objective panel of experts, if they put a lot of time into it, would come to. And in that sense, I think it is going to help reduce the patent litigation burden. I think it's going to filter out some of these patents in a more timely way than would have been done before. And I also think it's going to help patent owners in the sense that they're not going to get the same level of, I would say, rejections that we saw in inter-parties re-examination that were more mechanical than thoughtful. Okay, there was some of that going on in inter-parties re-examination, and I think a lot of that's going to be reduced as well. So my hope for this process is that it will eventually have an effect that it was intended to have in the legislative history, although it's not going to be a simple substitution of the patent office trial practice for the district court trial practice.
So to the extent it's used, you're thinking that the quality of the decider in the USPTO, or however the mechanism is being launched, will be higher, the
Yep.
quality of the...
Yeah, I absolutely think that. And that's based on the interim decisions that we've gotten out of the patent office so far. I mean, it can hardly... It would be difficult in the way it's designed to get a lower quality out of it than we got in inter-parties re-examination. People are chuckling because they see that as a slam on inter-parties re-examination, and it's not. I have plenty of criticisms of inter-parties re-examination, but this is instead of one examiner who's primarily in charge, and it's a high-quality examiner within the PTO. These are the highest grade examiners that are handling re-examination. We're moving up to the board level, and the board level staffed with lawyers, and often with people who have had the best service records within the patent office, quite often recently, people who have come out of private practice and patent litigation, a number of former Federal Circuit clerks. This is a relatively high-quality group of individuals judging these proceedings, and I think the level of quality that we've seen coming out of the interim decisions has been commensurate to that.
Are there any questions for the...
In cases where infringement is basically stipulated to, the only issue is validity, is then thought to parties agreeing to, in the arbitration context, for example, to let inter-parties review act as the decide validity, and then go with that, since there's no dispute about infringement.
Well, you threw in the arbitration context, otherwise I would answer that question yes.
Well, some means of making a finding. So they say to the arbitrator, we're going to, whatever comes out of the party's view, that you decide damages, because you've already agreed to it.
Right. We have seen that happen, at least in the district court context and in the pre-litigation context. I personally haven't seen that in substantive patent law arbitration, simply because I haven't been involved in that many substantive patent law arbitrations, and that's kind of a unique fact scenario. But there is certainly, overriding generally the idea that the district court will effectively send validity issues to the patent office by issuing a stay. Okay? Now, we had cases back in the 1980s where ex parte re-examination was first available, and there was something also called inter-parties reissue, I think, too. And you had a couple of courts ordering the parties to go back to the patent office, and then the Federal Circuit said that's not allowable. But you also have these pre-litigation situations where the parties expressly or tacitly acknowledge that the scope of the claims is going to read on the product. And they do, in fact, agree to go back to the patent office to let the patent office decide the issue, because they just don't want to spend that much money on litigation.
Yeah, one way that I see these new post-grant review proceedings is kind of as a proving ground to the patent office. And I wonder if kind of the next step is to follow in line with what some countries have had in place, such as in Germany, where it is the patent office that decides whether a patent's valid or not, and we take that out of the hands of a jury and out of a judge. Just simplify the litigation by only focusing on infringement, and if somebody wants to challenge a patent, you go to the patent office, who are the experts in validity, and challenge it that way. Right at this point, I don't think there are any legislative proposals to that, but does that seem like an appropriate next step?
Well, you raise, potentially a constitutional issue, but as a practical matter, whenever a court stays litigation, that's effectively what's happening, right? If they stay all the way through the end of the patent office process, and that's been found to be constitutional. Dividing the powers up as a statutory matter, I think, is something that probably wouldn't happen anytime soon. If it happened, it would happen more along the lines of the trend of district court decisions moves toward staying litigation in favor of the patent office proceeding. And all sorts of fun issues arise, of course, in our, what we call the dual track system, where you just have these two proceedings and they can run in parallel, and there's no interregulation of the timing, really. Or where you have countries, I think, like Japan, where they also have a sort of dual track system, but they have a different set of regulations on how the patent office decision governs the litigation and how the litigation decision governs future litigations. So it's a really complex area of law. I don't see us doing anything. I think that would be a very fundamental change, saying that validity was no longer a defense to infringement in a district court action, and that the patent office is solely responsible for that. So I don't see it happening.
How much of that is related to the fact that you have the executive branch and the judicial branch? Because the courts are using special masters to decide all kinds of things.
Mm-hmm.
It would seem like it would make a lot of sense if you have a group like that says to look at validity issues and instead consider them arms of the court. Special masters make a decision, but how much the patent office would say, no, we don't have money for that. We're not interested.
Yeah,
We have to work for free.
Yeah.
They would charge you a hefty fee,
It
right?
is an elegant concept, but.
It's the first time I've been called that.
Yeah. No, it is,
In
but
this context.
it's lawyers, and I just don't see it happening.
So
Did you have a question?
Well, I just want to comment. Have you seen this in Hatch-Waxman? So I'm thinking that, if you write a paragraph 4 letter, you typically say, I don't infringe the patent's valid and it's unenforceable. And I'm wondering, you're talking about, could you lessen the cost
Yep.
of it? Is this a way, because that's given the scope of that obligation.
Yeah.
It may actually be one way to make it cheaper for a generic to challenge at least part of patent that way.
So I think there are 10 inter-parties reviews in the Hatch-Waxman context right now. And I happened to discuss this very issue 2 days ago at the ACI Paragraph 4 conference in Chicago. You were probably there too. And I found myself, giving this talk about what inter-parties review is and how the procedure works and the lessons we've learned. And I think 5 or 6 times during that talk, and it's sort of similar to the conversation that George had this morning, I found myself saying, of course, in a paragraph 4 context, this is exactly opposite. Right? The motivations of the parties are completely different. It becomes incredibly complex when you talk about first ANDA filers, second ANDA filers. All of the IPRs that we have seen right now are second ANDA filers.
Yeah.
And why would you think that is?
Well, because the first ANDA filer doesn't want to validate for everybody else.
Right.
But now you can settle those cases, right?
You can settle those cases.
Well, then the FTC will
Yeah.
come after that. So
Yeah.
I think that's
Exactly.
right.
Right, so you can settle the cases, you can make the settlement agreements confidential except to the government or to parties in good cause, and that's exactly why that clause is there.
All right, we probably have time for one more question?
I have you now.
Yeah.
So I find, as an attorney, that you often know how a disputed matter is going to end up resolved.
Okay.
But the parties are not ready to settle.
Hmm.
They have to go through their litigation, they have to go through their discovery, they have to go through their pain before they get to the point where they're really willing to settle. 75 to 80% of IPR proceedings are in concurrent litigation. And so kind of on the settlement comment, it's a nice segue. I think IPRs are an opportunity to get those issues out much, much earlier than in litigation, which is
Yeah.
well discussed. So with respect to the settlement option of IPRs that you did not have in IPXs, I mean, what is your thought process on that? Do you think it will position the patent owner to be more willing to settle, especially when we start talking about non-practicing entities?
Yeah, I think it will, actually, and I think you're starting, at least in my practice, I'm starting to see the settlement option becoming a really big deal, especially where there are multiple defendants.
Yes.
Where only some of them have access to IPR, maybe because the rest were sued too long ago, so they won't qualify for the 1-year rule. And I think also through our experience with inter-parties re-examination, people respect now the patent owner, the patent office process in a way they didn't respect ex parte re-examination. So the fact that we have these inter-parties processes, that you can actually prosecute them to a conclusion within a reasonable time frame, and that the challenger has a reasonable chance of winning, which really wasn't true in ex parte re-examination, makes the patent owner have to respect that process, gives a huge incentive for settlement of that issue with respect to the challenger, at least globally.
Okay, well, thank you very much, and since we're the only thing between you and a break, we'll break here, but we are available for questions at any time during the break and this program, so thank you very much.